If she wants to say, I'll do the money, then we'll just put her on a payment plan on the money. If she can't make the decision today, I got to limit it. But if she wants to make the decision today, money or time, then we can work with that. But why don't we pass on this so I can call another file? You guys take all the time you need. Fonville. Okay.
It was each right for one.
All right. So, understanding all that, Ms. Stringer, are you pleading guilty to these charges? Are you doing so freely and voluntarily today? All right. Counsel, would you like to board here to get the facts that support the pleas?
Yes, I would, Your Honor.
I've shown an incident date here, Romulus, April 28th this year.
So, Ms. Stringer, so I'm going to take you back to April 28th, 2026. On that date, did you visit the address of 15085 Mesa Way in Romulus?
Yeah.
And is that in Wayne County, Michigan? And on that day, did you walk up to the door of that house and start knocking on that door? At some point, did you use your foot to strike the door?
I can't hear. I heard yes, and then I didn't hear what the rest was. Okay.
And in so doing, did you cause even a slight amount of property damage?
No.
Unknown. I mean, I think there might be some memory issues here, so I also would have no problem with the contest plea.
Your Honor, I would subscribe to that.
I'm all right with that. Hold on. You understand if you say no contest to the charge, you're literally saying, Judge, I'm not fighting that charge. So if I find facts that support the plea, we go forward and there's a sentencing. You understand that?
Just a moment.
Sure.
My client is okay with the no contest plea.
Okay.
And
You satisfied with the facts, Mr. Kaplan?
Yes, Your Honor. This report reflects that on the date showing the complaint judge, this young lady, the defendant, visited a home, not her own, caused a slight amount of damage to the front door, and also tried to enter the home unsuccessfully without permission.
Satisfied?
that's
I am too. I'll dismiss the original count one. I'm inclined to send her for a pre-sentence investigation, but I'll let you try to talk me out of it.
Your Honor, what I feel, if I may, is that this was an isolated incident. It was actually a mistake. I think maybe she was associated with a bad hombre somewhere, but at any rate, she seems to be doing well. I think you could sentence today.
I agree, Judge.
Okay.
It's $500 restitution that's set there. I believe that you can come up with a reasonable probation on the spot and speak.
Okay. All right. Go ahead.
Your Honor, Ms. Stringer is 20 years old. This is your first contact time system. Like Mr. Kaplan said, I think this was an isolated incident. She has worked before. She's looking for work now. I think this pending charge has made it difficult for her to secure her next job. She intends to, re-enter the workforce.
Okay.
We're grateful for the misdemeanor reduction. Hope that these offenses get expunged sometime soon. In the meantime, Your Honor, we would ask for simply imposing the restitution that was in the agreement. If there would be any probation, that it be minimally intensive. She lives in Taylor,
Yep.
so not exactly a stone's throw away. So I would just ask that any probation be limited to, you know, a few check-ins, maybe, you know, an alcohol test.
Gotcha.
Or intensive classes, or anything like that.
We agree on it.
All right, thank you. All right, Ms. Stringer, where did you work last time you had a job? Who were you working for? How long were you there?
It started like 2-3 weeks before.
Okay. How about the job before that? What were you doing?
I'm working at a clothing store.
Okay. All right. So this is a little bit off topic, but before you leave my building, go downstairs and ask if Mr. Taylor's still here. He shouldn't be at lunch yet. Ask Mr. Taylor what he's got for job opportunities in the area, like Romulus or Taylor. He keeps track of job openings for like entry-level jobs. He's usually got a pretty good list, so something might reach out to you. All right. Anything else you want me to know before I sentence you today? No? I can't hear you. Okay. All right. So I've got a problem with these restitution orders. Do you have the ability to pay $500? Not today, but I mean, can you get this paid in the next 5 months, 6 months? You sure? All right.
Run the average, yeah.
Yeah.
We recommend a $300 restitution.
$300?
Amorphous as to how much damage.
All right. It's your recommendation. I'll take it.
Thank you.
She's not gonna argue with you. All right. So you can get that done?
Yeah.
Okay. Was there any indication there was some kind of substance abuse involved in this?
No, don't do so, Judge. Thank you.
You got a driver's license, your valid license to hold 9 yards? Okay. All right, well, the $300 has got to be money because that's restitution. I'll give her the option. I could do some community service or work, excuse me, I could do some work program time instead of fines and costs. She's not working right now. She just have to be here at 8 o'clock in the morning. She picks the days.
So that would be work program as opposed to community service.
Well, I like work program because then she walks out of here. She knows she's got a schedule for X number of days. She bangs those days out. She doesn't have to worry about finding someplace to go. She just shows up here and does it. I'll give her fines and costs and give her time to pay.
Could we just do one in lieu of the other so she can kind of choose what works best for her after today?
Sure. Reasonable. All right, so here's what I'm going to do on 750.3806. Well, first of all, on both charges, it's 12-month non-reporting probation. That just means stay out of trouble. On the first count, which is the 3806, that one, I'm going to put the restitution on that file and $400 fines and costs or 4 days on the court work program. On the attempt illegal entry, it's another $400 fines costs or 4 days on the work program. What I'm inclined to do, counsel, is give her until June 12 on the first file to do the money or the work days, and then give her until July 15th on the second file. So that way she just knows she's got 30 days to either do the $400 in any event, she's got to get the 300 paid, but she's got the first file, she's got 30 days to do the 4 days or the $400, and then she's got another 30 days to do another 400 or another 4 days. And if she wants to pay 4 and do 4, however she wants to work it out. Does that make sense? Sure. We got the bodies we need for the next one?
That we appreciate, court's, assessment here. Is it possible just to give a little bit more time? What if we just make it like a, instead of a 30, 60 day, make it a 60, 90 day situation?
No, I'm not gonna wait that long to find out I got a problem. If she wants to say, I'll do the money, then we'll just put her on a payment plan on the money. If she can't make the decision today, I gotta limit it. But if she wants to make the decision today, money or time, then we can work with that. But why don't we pass on this so I can call another file? You guys take all the time you need. Fonville,
That's it, did you, sir?
David Champagne.
appearances on the People versus Fonville, please.
Or Sandy Allen on behalf of the people of Ryan.
Good morning, David. The defender service by action number P87788 on behalf of Mr. Fonville. Mr. Fonville, can you please state your name?
Joseph Fonville.
Thank you, sir. What do we got?
Then we're ready to proceed. We are seeking respectfully to call Denise Fisk by Zoom. Judge, in this case, Ms. Fisk is not in the state, he's outside of the state. The court rule, Judge, I know you're familiar with it, the criminal court rule gives your honor absolute discretion to allow testimony by Zoom, and you know that, I know. The only stipulation on the mandate is that the defendant either attend court or refuses to attend court.
Right. Counsel.
Your Honor, at this point, the defense objects to Zoom testimony and asks for a dismissal of the charge instead because the witness is not here to testify. The court rule that Mr. Kaplan is referring to, of course, is XCR 6.006, which refers explicitly to its civil equivalent, NCR 2.407. 2.407 lays out factors for your honor to consider when allowing Zoom testimony versus not. A couple of those key factors here are the opportunity for full and effective cross-examination. As the court knows, a transcript is produced, and say we get to trial, the witness is not available then, and the government wants to proceed just on a transcript. That's a confrontation issue, and today is not a full and effective opportunity for me to cross-examine this because I can't see her body language. I can't see if she has papers on her lap or on the table. I can't see if there's someone behind the camera coaching her testimony. And so cross-examination is therefore limited when we have Zoom testimony. Another one of those factors is whether there is physical liberty at stake. Obviously, Mr. Fonville is in custody and his physical liberty is at stake in this case. And finally, another key factor is the convenience of producing the witness. Ms. Fisk doesn't live out of state, doesn't work out of state, she is on vacation, and that's something that the government should have planned around at the PCC stage when we were scheduling this exam. rather than on the day of the exam. So for all of those reasons, we would ask for a dismissal in lieu of inflict testimony.
Thank you. Yeah.
Here, the 6 of them confrontation right is a trial right now, preliminary examination right. U.S. Supreme Court has so held on many occasions. Now, the Michigan Supreme Court devoted an abundance of effort in devising this rule, which is MCR 6.006 parentheses 4. And I can repeat what I said earlier, but the court gives you discretion, Supreme Court gives you discretion. Now, let's assume that Judge Oakley decides, no, let's have the witness. All right, case dismissed without prejudice. He'll be rearrested, he'll be rearraigned, and we'll try him then. Judge, I don't see any prejudice in the experience attorney with the cross-examination witness.
All right. Anything else?
Nothing further.
All right. Thank you for your arguments. I'm going to allow the testimony today by Zoom. Ms. Fisk, can you raise your right hand for me? Do you swear or affirm tell the truth, the whole truth, nothing but the truth today?
I do.
All right. Looks like you can put your hand down, ma'am. Looks like you're in an automobile.
I am.
Are you alone in that automobile?
I am not. We're on our way
Okay.
back to Michigan.
I'll say that again.
We're on our way back to Michigan. We're into.
Okay. All right. So I'm assuming your driver has nothing to do with this case or your employment?
No, he does not.
Okay. All right. Are we ready, Mr. Kaplan? Go ahead.
Thank you, Brian. Judge, I missed it, swearing away.
I did.
Thank you, Judge. Good morning, Ms. Fisk. Can you see me?
Good morning.
Can you see me?
Not great. No, I can't actually.
Should I move? I go to the
Try the podium.
Ms. Fisk, can you see me?
Yes, I can.
What do you do? I know we've been Steve Campbell with the prosecutor's office. Ms. Fisk, where are you employed?
Meyer in Belleville.
How many years have you been working in lawyers?
34.
What street?
Pardon me?
What street is the Meyer located on? The store.
Van Buren Town.
What is your current position with
I'm
Meyer?
sorry, could the witness repeat her last answer for audio file?
Ms. Fisk, give me that address again, please.
The address is 9701 Belleville Road, Van Buren Township.
Thank you.
What is your current position, Ms. Fisk, with Meyer?
I'm a store detective.
Can you estimate for Judge Oakley the number of cases you investigated involving shoplifting at retail stores?
In 34 years,
Are
I couldn't even guess.
we talking hundreds, thousands? What are we talking?
Oh, yes.
I'd like to take you back in time to April 29th of this year, 2026, at about 2 p.m. Were you working?
I was.
Did you have the opportunity on that day to meet a gentleman or see a gentleman named Joseph Fondle?
I did.
Did you see Joseph Fondle?
Pardon me?
First, see Joseph Fondle.
Objection, there's a lack of foundation as to how this witness could identify any individual as Joseph Fonda.
That's a cross-examination. She could testify, she knows them, and
It'll work for Cross. Go ahead.
thank you. Regarding Joseph Fondle, where did you first see him on April 29th of 2026?
In our liquor aisle.
Where were you when you saw him in the liquor aisle?
I was in our camera room.
Describe the liquor aisle to us.
It's an aisle, several feet long with liquor.
Now, on that day, was your store giving away liquor to people?
No, they weren't.
You said that you were able to observe this through surveillance. Can you describe the surveillance to us?
It's closed.
Go ahead.
Pardon me?
Go ahead, describe it.
It's closed circuit television. We have cameras throughout the entire store.
Were the closed circuit televisions working on this day of April 29th? Were they
Yes.
functioning properly?
Yes, they were.
How do you know that, Ms. Fisk?
I was working them.
Ms. Fisk, if you saw Joseph Fondle again, do you think you'd recognize him?
I would.
How does she look around the courtroom, you know? Look around The courtroom.
Well, she's looking at everything you're looking at on that screen in front of you.
Look around the court and tell us whether you see Joseph Conwell.
I'm having a hard time seeing in the courtroom.
Can we show the council table?
I don't have the ability to do anything with this.
I can't zoom this screen actually.
I think it's zoomed in as much. The whole courtroom is zoomed in as much as it can.
Yeah, this is what we got.
That's the main courtroom.
That's helping a little bit.
And then do the other one.
I mean, I'm terribly sorry. I can see two people, but I can't see it to.
Is there any way to magnify?
I am going to object to identification.
She's got it zoomed as much as it'll zoom. So, hold on, guys. It's zoomed as much as it'll zoom. Go ahead.
Would object to identification at this point in time. I think all the court has done, all the court can do in this particular instance is literally zoom in on my client, and that is incredibly suggestive as to who this witness is supposed to identify in the courtroom. It also looks based on the portrait orientation of Ms. Fisk on Zoom that she is on a phone, which is a small device that's also supported by the fact that she is in a car. That's a small device. She said she can't zoom in. I expect that her ability to see, even though the court has zoomed in on my client, her ability to see is limited. Any identification would be incredibly suggestive and unreliable, and so I ask that the court decline to make it.
Well, of course, counsel presupposes that she knows my case. I might have another witness who can identify. I would like to proceed with this witness.
Go ahead.
What she knows.
Go ahead.
Ms. Fisk, can you describe the person you saw on CCTV?
A black male, dark glasses, like black rimmed glasses, wearing all black.
Had you seen him before at your store?
I had not.
What did he do, if anything, while he was in the liquor aisle in Meyer?
Pardon me?
Man do while he was in that liquor aisle at Meyer?
He selected liquor and placed it in his cart, and he selected liquor and concealed it into his coat.
Can you tell the judge the number of bottles of liquor this person selected?
He selected 7 total bottles while in the liquor aisle.
What type or kind or class of liquor is involved?
Tequila.
You know what those bottles were selling for on that day of April 29?
I wouldn't without referring to my report.
Judge, I have a report here. It's on page 18 of the police report. Would it refresh your memory? You saw the amount,
Yes.
the retail amount?
The amount for each bottle would be itemized in the section of evidence.
The total is shown on page 18. Is that a total that you rely on? The
Yes.
total retail sale amount?
That also includes the watermelon and the chips. That's just not the liquor.
Right. Can you show an amount, 6 products for $377.82, $377.82. Does that refresh your memory?
Yes, except that's 9 products.
9 products, $377.82?
Yes.
Well, what did the gentleman do with the liquor? Did he pay for it?
No, he did not.
Did he try to pay for it?
No, he did not.
Did he tell anyone that it was his birthday and he wanted free liquor?
No, he did not.
Want the store to give away the liquor?
Pardon me?
Want the store to give away the liquor?
We do not give away liquor.
He had opportunities to pay for the liquor.
He did.
Explain to us.
After he concealed the liquor on his person, he proceeded to the front of the store to our self-checkout lanes. And he actually placed the bag of chips and the watermelon into a Meyer bag without scanning them as well and walked out the grocery doors.
Does anybody give permission to take the products, merchandise, and not pay for them?
No,
Are there any impediments for him paying for them, such as, had there been some type of explosion where he couldn't go buy a cash register?
I'm pardon me?
Sure, was there any reason why a person may not have paid for that merchandise?
No, no reason.
What does he do with the merchandise?
The liquor he concealed into his coat, into his shirt, and the watermelon and the chips he put into a Meyer bag at the register.
Ms. Fisk, do you know whether he stayed in the store or left the store?
No, he exited the store.
Are you able to tell the judge where he went when he exited the store?
I can. He went to the passenger side of a SUV. I believe it's blue in color.
What did he do then?
They left the property.
Any payment by him at that point?
No,
Did he come back the next day and say, oh, sorry, I forgot to pay?
no.
Are you able to tell us the brand of the tequila? You know,
I can't verbatim, but it would be listed in the evidence, the bottom of my report.
thank you, Judge, nothing further.
Cross, Ms. Munger?
Ms. Smith, you say that you were in the camera room at Meyer, is that right?
Yes,
Were you, so when you saw, everything you saw that you just described on cross-examination, you saw on CCTV?
correct.
And were you watching that CCTV in real time, or did you view it after?
In real time.
Did you ever leave the camera room and see, the suspect of the retail theft with your own eyes?
I didn't want to lose as observation.
So it doesn't help.
I didn't know.
Did any employee at Meyer, to your knowledge, intercept the suspect before he left the property?
My greeter attempted to stop him because the electronic alarms went off on his exit.
But no one successfully stopped the suspect before they left the Meyer property, right?
He refused to stop for her.
Okay. So that's no.
No.
You said that the suspect got into a blue SUV.
Pardon me?
You said the suspect got into a blue SUV.
Yes, I believe it was blue. He was the passenger.
What did you do next?
I contacted Van Buren.
And you were not able to give them a license plate of the SUV, correct?
No.
No further questions.
One question, Your Honor. Ms. Fisk? No, none, but when you say you contacted Van Buren what?
Police department.
Thank you, Judge.
No recross, counsel. All right, Ms. Fisk, thank you. Travel safely.
Thank you. Have a great day.
You as well, ma'am.
One of the people called Tori Pierce.
Pearson?
Yeah.
Ms. Pearson, all the way up front, please. Ma'am, would you raise your right hand for me? Do you swear or affirm tell the truth, the whole truth, and nothing but the truth today?
Yeah.
Come on, right up here. I'm going to stick you in this chair. Watch your step on this ramp right here. Make yourself comfortable in that chair. And after you sit down, would you state your name and spell your last name, please?
Tori
Pearson, P-P-A-R-S-O-N.
Thank you, ma'am. Mr. Kaplan.
Hey, Ms. Pearson, good morning or afternoon to you. Hey, my name is Steve. I'm one of the prosecutors here in Wake County. Nice to see you. Are you employed?
Yes,
Were you working on April 29 of 2026 in the early afternoon?
yes.
Where were you working on that date approximately?
On the north side of Myers.
Which
North
Myers?
side,
Which Myers School?
Belleville.
On April 29, how many years or months had you worked at Myers?
I'm going on 5 years,
Are you part-time or full-time?
part-time.
You like to work?
Yes.
Ms. Pearson, what were your responsibilities on April 29 of this year at around noon?
I'm a greeter slash, if someone steals something, our alarm goes off. I attempt to stop a person. If the person doesn't stop, or if they do stop, I go to the phone, I call our detective, tell the detective what the description of the person is, and they take it from there.
Ms. Pearson, the judge clearly knows what a greeter is, but define the responsibilities of the greeter.
A greeter is, we stand at the door if someone attempts to try to take something out of the store when their alarm goes off. We are to ask them to stop. Sometimes they stop, sometimes they don't.
Ms. Pearson, did anything unusual happen that day at about 12 or 12:30 at the Myers store where you were working as a greeter?
Yes,
What happened that was unusual?
the alarm went off.
What does it mean when the alarm ignites?
So the alarm goes off, I need to check that person and see what is in their bags.
What causes the alarm to detonate?
Sensors. Sensors. That is.
I'm sorry. What are the sensors gauging? What are they measuring? You said the sensors.
It's sensors in different things, different products that Myers have. And when the sense, if you take it and it hasn't been, deactivated, that usually lets us know that someone might have taken it. And so we have to check your receipt to see if you actually bought the product or not. Match to see if reason why the sensor.
Did you have any type of encounter with a person at Myers store while you were working as a greeter on April 29?
Yes.
Tell the judge what type of encounter you did.
The sensor, when the sensor go off, I ask whoever the person is to stop. Sometimes they do, sometimes they don't. That particular day, I asked the person to stop on several occasions, and he didn't.
How far were you from this person when you asked him to stop?
They had to go past me.
When he passed by you, how close were you when you first noticed him?
A couple of feet.
Is this a man or a woman?
Man,
Is it black or white man, Hispanic, Asian?
black.
Had you seen this person before?
No.
If you saw him again, you think you'd recognize him?
I don't know. I can't say until I actually see the person.
Can you look around the court and tell us whether that customer is here?
No.
You saw a photo of this person? Think it might refresh your recollection?
If I can see the photo.
You're gonna be able to witness?
Sure.
Trying to find the page here for council. Let's mark these as proposed exhibits 1 and 2.
It's fine.
May I approach?
Sure.
I'm giving you 2 photographs marked as proposed exhibit 1 and 2. I'd like you to look at those and see if they refresh your memory as to the appearance of the customer.
I remember this actually.
Now, looking around the courtroom, do you see that person?
100% sure.
Well, how sure are you?
as far as that, picture of that guy, but if you're, he has like glasses on where nobody even has glasses on with him.
Now, the person that the sensors went off, did you have a conversation with him or her? With him?
Yes, I tried to stop him. And tell him to stop on 7 occasions, he wouldn't stop.
What did you do when he wouldn't stop?
Our procedure is to call our detective, give the detective the description of what the person looks like, and they can be able to get on the camera cam.
Do you know whether this person had any merchandise with him?
I can't say 100%. It has to be what it says before.
Did this person make any effort to pay?
No,
Did the person offer any explanation for that?
no, he just kept walking.
Did he respond to your questions?
No.
You think he heard your questions?
Yes.
Thank you. Nothing.
Counsel,
No questions, that's what I'm saying.
ma'am, you can step down. Thank you for your time. Watch your step on the ramp.
Judge, we didn't mean to squander your time.
It's all right.
We're surprised by the testimony for the report. Obviously, the case has to be dismissed at this point without prejudice, unless Your Honor would grant us, should have asked to be adjourned earlier. So the case, I'm sure, will be dismissed without prejudice. We will refile it.
You are correct. Dismiss without prejudice.
I guess that's the Thank you.
Mr. Martin, are you ready on Springer?
Yeah.
Come on up. Back on the record.
Thank you, Judge. Member of the service, Terry Martin, please provide me to the door representing Mr. Stringer. Stringer, state me one more time.
Yeah, sure.
And Judge, after discussing my client's options with her.
Yep.
Ability to pay is limited right now.
Sure.
So talk about ability to do work program.
Yep.
8 days by July 15th. And Ms. Stringer will go with that option.
Okay.
Did you just want some clarification about this $300 restitution?
Yeah.
You said a 12-month non-reported probation and, 300 must be paid by the end of probation.
Well, I want it paid before then if she can, but I understand she's not working right now. Right.
Or there's not a specific deadline that the court is.
I mean, I'll put her on a payment plan. What do you want to pay? How much? How often? Make some kind of commitment and we'll set that up. Okay. And then you can always pay it off early. And if you get a really good job before you're done with your 8 days and you want to pay money instead of doing the days, we'll convert there. All right.
So I think the whole sentence would then be 12 months non-reporting probation, $300 restitution on a payment plan, 8 days in the work program, first 4 by June 12th, next 4 by July 15th. That's it.
First 4 by when?
You said June 12th.
Okay. I thought you said June 4th. I'm like, no, that's too quick. Okay.
June 12th, and next 4 by July 15th. No other terms or conditions.
Yeah. Stay out of trouble. That's what probation's all about. Okay. Anything else?
Nothing.
All right. Go downstairs, make arrangements for that $50 a month. And we'll always take money early so you can get out from under that quicker.
Thank
You're
you.
welcome. You're welcome. Always a pleasure, counsel. Shutting down.
Yes.
Joe, you want to turn that TV off?
Leave, because every time I went out my front door, she would start up again.
Thinking and feeling, case was pointed.
I was scared for my life.
Thank you.
Mr. Holman?
May I approach, Your Honor?
Sure.
Thank you. Ms. Sigsby, how are you this morning?
I'm good, how are you?
I'm doing my best. I'm Ms. G's attorney. And my name's Zach Holman. I have a few questions for you today as well. If you don't understand the questions I have, which is entirely probable, just re-ask or ask me to re-ask the question, please. Don't try to guess. Mr. Capital will take care of you in that regard too. Isn't it true you lived as Ms. G's neighbor for over 3 years?
Yes.
And in that time, since you've lived with her, is it fair to say that there was a period where you were more amicable with her than you are now?
Objection to relevancy doesn't establish an element of the crime or disprove an element of the crime. They could be best friends or mortal enemies.
If, Your Honor, if I may continue with the line of questioning, you'll see where I'm going with this.
Without a response to the relevancy objection?
I think it's entirely relevant. It goes to the reason that the complaining witness made the call to the police. It goes to the nature of why the matter escalated in the first place that day, as to what she saw, as to what other complaining witnesses saw. I think to narrow it down to the element of whether Ms. G had a taser that day or not is a little too narrow for the scope to that response.
Your Honor, she either pointed the taser at her or she didn't point the taser at her. That's what we're here to discuss. We're not here to determine whether they're best buddies or mortal enemies.
In fact, though, Your Honor, we are, because one of the essential elements to describe is whether Ms. Sixby was truly afraid for her life. So if she doesn't know her at all, as she testified, or whether she does know her, and this is just an issue between the two of them, where she knew that Ms. G was actually not going to go retrieve a gun and fire it at her, but it was a continuing issue between the two of them, then that does impact Ms. Sixby's state of mind, whether she was in fear of her.
Go ahead.
Sorry.
No, you're all right. Go ahead.
Felonious assault can be proven one of two ways. It's either an attempted battery or an attempt to place somebody in fear of suffering a battery with a dangerous weapon. So I don't see how this inquiry diagnostic agreement is. This inquiry proves or disproves anything controversy. Might be interesting. Maybe a jury wants to hear the details, but you don't need to know those details.
Then, Your Honor, it goes also into Ms. G's state of mind. And whether how well they know each other, it is absolutely relevant to what Ms. G intended that day.
I don't think her state of mind is relevant at all. It's whether or not the alleged victim was put in fear.
Well, then I stand by my previous response. I do think that the level to which she knows Ms. G, if she had just moved in, she's never seen her before, or if she's seen her as her next door neighbor for the last 3 years, is relevant as to whether she was in fear for her life.
I'll allow very limited questioning on that specific issue. What this witness knew about that lady's propensity for threats or violence, because that's what you're saying.
Thank you, Your Honor. So, Ms. Sixby, let me back up before we got a little sidetracked. I think my last question was, you've lived next door to Ms. G for 3 years, or over 3 years, right?
Yes.
And so over that time, how many conversations have you had?
Probably
Objection
five,
as to relevancy.
Probably 5.
like 5 or
Okay,
Sharon's talk.
all right. How many conversations she's had?
Oh,
You don't talk, because I'll remove you from the courtroom. The issue is whether or not she thinks this lady has the ability to make if a threat is serious. That's what you were relying on, right? Okay, so whether or not they've had 40 conversations or 4,000 conversations doesn't get you there. Not in a limited line of questioning. So maybe you got to ask her specific questions about threats or violence.
Has Ms. G ever before the date that we're talking about here made any threats or just
Objection. It's not relevant on the day of question. That's what we're concerned with.
I'll allow it. I'll allow it on a limited basis.
yes, before the date in question?
I wouldn't say threatening,
Okay.
that I know, like, I didn't know her like that. The first time I met her, she called the cops on me. Because she said I parked in her parking spot. I've always tried to stay away from
None of
her.
this is relevant.
Yeah, let's move on.
I did not.
Okay, there's no question.
Okay, Your Honor, I believe Mr. Catlin interrupted when she was answering the question that I posed to her. And
She was talking about your client calling the cops on her because of a parking violation.
Right. And I believe before that, you were talking, said that you've had about 5 conversations.
Very limited conversation.
Well, I'm asking you about those limited
And
conversations.
we object as to relevance.
And in those limited conversations, your testimony is before the day that we're testifying about today, she had never made a threat towards you.
Objection as to relevancy, it's not an element of the crime.
I'm allowing it.
She has not threatened me, but she has done stuff to try to provoke me. That's what she always has been doing, and I kept forgiving her. I just want peace.
What was she doing to provoke?
She's never done my door.
Okay. Okay, ma'am. I don't know, maybe you've never watched a show on TV where there's a trial. But when an attorney stands up and says object, the witness doesn't talk.
Okay.
Okay? Make your objection. Response.
Your Honor, I think if I can request for an instruction, if we're gonna get the same objection, we should have on every single question. It is an essential element of the crime. I am keeping my questions very limited to what you narrow the scope of this line of questioning to, and we're still getting an objection every time. It seems like we're clearly trying to interfere with the complaining witness's testimony. I'm asking very specifically about her frame of mind on that day. That is contextualized by the history she has with my client.
I'll allow it.
What would my client be provoked?
Smear hamburger on my front door after I went to work.
When did that happen?
Your Honor, we object, these are prior bad acts under 404B, and they're being introduced against her, this client.
If he wants to introduce him, let him. I get to decide that today.
And she has followed me. I had to make a police report after what happened, because she was following me, and my daughter, twice.
And when in proximity to the day in question that we're testifying about today, did the 2 incidences that you just described, to the best of your memories?
When did they happen?
Yeah.
About a week ago, 2 weeks ago.
Okay, so my initial question was, times you interacted with Ms. G, my client, before the day in question. Okay.
We object, it's been answered, and it's also not relevant.
And it's confusing. So this incident happened in January. Yes, ma'am?
Yes,
The taser incident.
yes,
The incident with the hamburger and the following, was that before January or after January?
before.
Okay. About 2 or 3 weeks before?
No, about a year.
Move on.
Okay, so any other incidents of provocation that the term of use from my client besides the hamburger, hiding window, the incident of stalking where you call police?
Since after,
Before January.
Well, I'm sorry, before June.
there was incidents where she would be like trying to provoke me, or she would try to get information out of me, apparently because of the stuff that she was saying on the day of the incident, of information that she knew, and the only way that she would know that information is if she was following.
Okay. Yeah. My initial question, yes, I agree with Mr. Dickens, it's no longer relevant. But just to close this line of questioning, was there any other incident with that, let me re-ask, besides what you've already testified about, before the incident in January, did you have any other interactions with my client where she either provoked you or allegedly threatened you? Okay. Were you looking for a reason to call the police on Ms. G?
No,
Why did, On the day in question, in January, isn't it true that your mother-in-law was involved in these?
Judge,
Or
that's the problem.
I don't have a mother-in-law.
the,
Objection, ask the see.
Okay.
Doesn't prove or disprove anything in controversy.
well, actually, Your Honor, the response is, I move you to the day in question. And there is another witness, and I'm sorry, it's a familial relation, and I'll correct the record. But absolutely, she was involved. She bore witness to Miss G being there. And my line of questioning is about where ultimately the complaining witness was when the alleged threats were.
We have a trial within a trial here.
Yeah.
You look
And
at,
she's already testified that they were approximately 6 or 7 feet away when the taser was involved. So I don't know what more you're going to get about proximity.
Well, then let me narrow it down, please, Your Honor.
Try.
Thank you, Your Honor. It is, my line of questioning is specifically, where were you in terms of your proximity to your doorway of your apartment when Miss G allegedly threatened with her taser, alleged taser?
I was on my front porch next to my front door by the farthest, right here. So I just walked out.
You had just walked out of your porch.
I just walked out of my house.
Onto your front porch.
Yes, onto my front porch.
Thank you.
She came out.
So you had just walked out of your house onto your porch.
Judge, and yes and answer.
Good hands. Go ahead.
And was that the first time you saw Miss G with what you believe was a taser?
Yes, because she's acted at me.
Hold on, if you could just answer the questions that I asked you, please. When did she zap it?
She walked outside. She walked outside screaming, talking about she had a gun in the house. She was going to shoot me with it, and she had the taser in her hands, and she zapped it 3 times that day.
Okay, that was when you came out of your house.
Yes.
So
Your Honor, excuse me.
where was it?
I'm being distracted by the.
I'm going to put you in the lockup. If you can't sit there without making any noise, you'll be removed from the courtroom. Do you understand that?
Okay, so my question really was, when did Miss G threaten you with the taser? Was it before you went into your house? After you came back out of your house, both?
She said she stepped out of the front door onto the porch. Your client came out and they had the confrontation on the porch.
If I may,
No, you can't. I got 6 exams today and I don't need to hear the same stuff 4 times. So ask a new question that elicits new information.
okay, where was Miss G when she threatened you with the taser?
On her front porch.
Where in proximity to your house is her front porch?
Like
6 or 7 feet away. Sit down. You're done with cross. Do you have any redirect?
Oh, wait a minute.
Thank you.
Put my objection on the record.
Feel free. Any other witnesses? Any defense witnesses?
No.
Any argument?
Yes, Your Honor. The witness testified a taser was pointed at her distance of 6 to 7 feet. She was afraid, actually fearful for her life. Thank you.
Your Honor, we don't believe the elements of felony assault with a felonious weapon that occurred here. We believe, if anything, the charges should be dropped to misdemeanor assault. And we ask that you would find that the prosecutor did not meet his threshold for a preliminary exam and would not find so. Thank you.
Because there was no testimony about a felonious weapon?
Your Honor.
I'm not familiar with what a felonious weapon is.
I would have gotten into more details regarding what our lovely complaining witness perceived the weapon to be. I will reserve that argument for circuit court. I don't believe that it's a felonious weapon in this case.
Okay, I don't even know what a felonious weapon is. Is that the same thing as a dangerous weapon?
I don't believe that it meets the definition of a dangerous weapon, making this movie structure.
Okay. Bound over. AOI is next week, 9 a.m.
Thank you, Your Honor.
This courtroom hearing involved two separate legal matters that highlighted important criminal procedure issues. In the first case, a 20-year-old defendant accepted a no-contest plea to reduce charges after admitting involvement in a property damage and attempted unlawful entry incident. The judge carefully reviewed the plea agreement, confirmed that sufficient facts supported the charges, and focused heavily on rehabilitation rather than punishment. Taking into account the defendant's lack of prior criminal history, young age, and employment challenges, the court imposed 12 months of non-reporting probation, restitution to compensate the victim, and an alternative sentence allowing either fines or participation in a court work program. The judge also demonstrated a rehabilitative approach by encouraging the defendant to seek employment opportunities and providing flexible payment options for restitution. The second matter centered on a contested preliminary examination involving alleged retail theft and later a separate neighbor dispute involving a taser. A significant legal issue arose when the prosecution requested testimony from a witness appearing remotely via Zoom. Defense counsel objected, arguing that remote testimony limited effective cross-examination and raised confrontation concerns. The judge rejected those arguments and exercised discretion to allow the testimony, noting that preliminary examinations do not carry the same confrontation rights as a trial. During the neighbor dispute hearing, defense attorneys attempted to explore prior conflicts between the parties to challenge the witness's credibility and fear of the defendant. The judge repeatedly limited questioning to relevant issues, emphasizing that the central question was whether the alleged victim reasonably feared harm from the defendant's actions. After hearing testimony that the defendant allegedly threatened the witness while displaying and activating a taser, the court found sufficient probable cause and bound the case over for further proceedings. Overall, the hearing demonstrated how judges balance defendants' rights, evidentiary rules, witness credibility, and procedural fairness while maintaining courtroom order during contentious testimony.